Hello, good evening, and welcome to Real Estate with Bimpe. My name is Ade Bimpe Ariola. I'm sure you already know that. And I'm the real estate consultant who is here with you every Tuesday and every Saturday discussing everything real estate. Today, as we have been doing in recent weeks, we're looking at another real estate title document. It's not exactly a title document, but it shows up in real estate transactions. When we get into the conversation, you would understand it. Today, we are discussing letter of administration or letter of probate as a real estate title document. But today, I'm not going to be having the discussion by myself. Today, I'm not going to be exposing you to the facts myself. Today, I'm going to be sharing an interview I had with a senior lawyer who is vast in real estate matters. Her name is Mrs. Tara Aishida. She is 30 years post-call as a legal practitioner. She has vast experience in administration of estate and family matters. She has served as company secretary for real estate companies. She has served as external solicitor for banks in real estate transactions. She has served as company secretary for real estate companies. In fact, she is currently a liaison officer for one of the most important parastatals in real estate transactions in Nigeria as we speak. I know she doesn't want me to mention this, but I just need to know that she knows what she's talking about in real estate transactions. So enjoy the interview, and I'll be right back at the end with a few thoughts for you. Take care.
The letter of administration is a document that is issued by the High Court of whatever state the deceased lived in or had property in, and it's a letter issued in respect of a personal and real property of a deceased person who did not leave a will. A letter of probate is issued by the High Court of a state in which a person that the deceased, lived in or resided in or has property in, but he left a will. So the difference between the letters of administration and the letters of probate is the absence of a will. So if there's a will, there's the letter, you go for the letters of probate. But if there's no will, then you go for the letters of administration. Now, if the person left a will, to get a letter of probate, you will have to first of all get a copy of that will. And so the first thing you're going to do, if you know the deceased or the testator's lawyer, is to go to the lawyer and get a copy of the will. Now, most times the will have been registered in the probate registry. Sometimes it's not. Sometimes the will can be made, but it's not deposited in the probate registry. Your lawyer applies for the will to be read, and the probate registry searches for the will, locates the will, and then they write a letter of invitation to the beneficiaries of the will, of the estate, asking them to come at a particular date and time, for the document to be read. So the will is read in court, by the probate registry officials, and thereafter, then it is time to prove the will. So proving the will is simple. It's just making an application to the High Court of the state in which the deceased person resided, and a lawyer does that. You go to the High Court, you apply, they would attach the will to the application, and you will apply for letters of administration. Now, the process between letters of probate and letters of administration, there's processing it. The main difference, is in that for the letters of probate, you don't need to publish it in a newspaper. So you don't need newspaper publication because already the testator has named the people that he wants to administer his estate. So once you fill the form, because you get a form, you pay for the form, you fill the form, the executors as named in the will sign, and give the information, the necessary information as requested on that form. And then the estate is assessed, by the Lagos state government or whichever government, of the state that the property resides in, and then once it's assessed, you get to pay the fees. It's normally 10%, of monies in the bank and the value of the property if it's real property. So if there's property involved, you're now going to go to the valuation department of the probate registry. They're going to visit the property, and then look at it. So the valuation is dependent on the area of where the property is located, the structure or any, if any, of the on the property, and the kind of structure. So if it's a bungalow, it's valued differently. If it's a 4-bedroom flat, is valued differently. If it's a skyscraper, is valued differently. And this, for Lagos State, they've zoned the property, the area, into different zones. So there's a minimum that is applicable in whatever area of the state that the property is located. So once the valuation is done, you pay that money to the court. Executors come for a meeting. They want to know the executors. They want to be sure that the person that is presenting themselves as the executor is the person that is named in the will. So the executors come, they bring their ID card, they bring the passport photographs, things to show that they are there. They are the ones named in the will. And then they come with a witness. One of the witnesses, there are 2 witnesses that attest to the signature of the testator in a will. So the requirement is for one of the witnesses to come and say, yes, the testator made this will. I was there when he signed. So all the executors and the witness would attend a meeting at the probate registry. And once all that is done, money is paid, then the document is issued by the High Court. So if, for example, you came to me and you say, oh, I have a property I want to buy. I've been told that the person that owns the property is dead, but there are letters of administration that have been issued in respect of the property. Now, the first thing I will say is, let me see the letter of the copy. Ask for a copy of the letters of administration together with the documents of the title of the property. So once I see that, I would conduct a search at the probate registry, because there are cases where people have brought fake letters of administration, fake letters of probate, and trying to assign other people's property without having that authority to do so. So we would go there, we'll confirm to see if indeed the letters of administration that are being bandied about, emanated from that probate registry. One, also we would confirm to see if for estate, for land in particular, if that land is included in the letters of administration, because sometimes people, in a bid to save money, they do monies in account first, and then leave real property until when they are ready to sell. So if the letters of administration do not, or even the probate does not include the property that has to be sold, then they have to do an additional letter of administration. That is very important, because if it's not included in the letters of administration or probate that they have already, then that means they don't have authority to sell that property. And it so happens sometimes it's not they've not been fraudulent at all. Sometimes you don't discover that the testator or the deceased person has property until after he has passed. Or it might take some while for you to discover, or maybe shares, maybe property, or maybe somebody calls and say, oh, this person he owns this property, so it's not fraudulent if the property is not included. But all that will be needed to do is to ask that the property be included, and then the administrators will do an additional letter of administration or probate, as the case may be. Once that is established, that the letters of probate or administration include the property in question that is being sold, the next thing is a deed of assent. Now, what is a deed of assent? A deed of assent is a document that transfers property that has been assigned or that's been bequeathed to someone, transfers it to the beneficiary, so to speak. So if, for example, there is a will, let me give an example of a will, and a man says, I appoint A and B as executors of my will, and says further down in the will, I assign and devise property X to Mr. C. Now, what will happen after they've done the letters of probate is that the administrators A and B will now do a document which is called the deed of assent, transferring that property to C. So the deed of assent becomes the title document of C. So that's what he would use to sell if he wants to sell, or he would use to, manage the property. It's not the letters of administration or letters of probate. No, it will be the deed of assent. If somebody came to me now, for example, and said, "Oh, these letters of administration or probate has been given over this property," then the next thing I would ask, after confirming the genuineness of the documents is brought, is, do you have a deed of assent from the executors or from the administrators? If he doesn't have, or she doesn't have, then they need to get that. So that deed of assent will now be what will authorize him to manage and to own and to control the property devised. When the deed of assent has been given to the beneficiary of the estate, then the person, like in the former example that we gave, Mr. C, now goes to the land registry in whatever state and registers the deed of assent that has been given to him and that has been executed in his favor. So if he wants to sell, he is going to execute a deed of assignment for his buyer, but his root of title is the deed of assent. So he's going to give the buyer a deed of assignment, but the buyer is going to get copies of the deed of assent from him. He's going to get copies of the letters of administration or probate from him, and he's going to get the title documents from him. The amount that it will cost to process a letter of administration cannot be, it's not a standard rate. And that's for very many different reasons. One, it depends on the amount, on the value of the estate. The value of estate differs from person to person. So the amount I'm going to pay over estate A might not be the same amount I'm going to pay over estate B, because estate A might have all sorts of things. My man might have shares, might have money in the bank, he might have property, and he wants to put everything in the letters of administration. So, and B might have just money in the bank, maybe 100,000. So it's 100,000, and maybe A that has 1 million in his account. Of course, B is going to pay less than A. So one can't pinpoint and say, oh, this is the amount that is going to cost you, until the estate has been valued. It's just 10% of the monies involved. So why does it take so long to get these letters of administration and probate? Well, there are several factors involved. First of all, the administrators or executors that want to obtain letters of administration from the court. First of all, your documentation is key. You have to have an official means of identification, and when you say official, it's either the data page of your passport, driver's license, permanent voters card, NIN, national identity card. Those are the verified and approved means of identification. Then also there's a lot of fights in the family. So if, for example, is a letter of administration where there's no will and the executors have been stated, they now fight amongst themselves as to who should be administrators, because who is an administrator controls and manages the affairs of the estate. So it's very important. So sometimes families can't meet up and say, oh, this is who should be, and select their administrators. Also, the death certificate, for example, is not the one from the hospital. So you must collect a death certificate from the National Population Commission, to start the process. Another important reason for the delay is finance. Now, once the the estate has been valued, the next thing to do is to pay. And sometimes nobody wants to bring out money to pay for the letters. Everybody's looking at, okay, you bring out the money, so sometimes the money assessed, especially when land is involved, might be so much. Sometimes when the land is located in high end areas, maybe like VI Ikoyi, you could pay as much as 10 million, 12 million, 3 million, to the state government. So who is going to bring that out? In fact, that is one of the main causes of delay. trying to get the money. But there's a way out. If the money in the deceased account can cover the cost of the valuation or the amount payable to the government, then you can write, the lawyer can write to the probate registrar, who now directs the bank to take the monies out and give it to the state government. And then also there's bureaucracy, because these are files passing from one desk to another. I remember just some weeks back, I needed to do publication for letters of administration for someone, but the person that was going to assess, or was it the person that was going to approve the assessment, lost his wife, and was on leave. My approval was pending until he came back. And then sometimes maybe additional, if you've now discovered an additional asset of the deceased person, sometimes looking for the files takes a while. Searching for files takes a while, because the registry, at least for Lagos State, is just uploading the documents on the system, so it takes a while to look for files. And then also, for example, letters of probate take less time than the letters of administration, for the mere fact that for the letters of administration you must publish a newspaper advert in the dailies, stating that so and so person has applied to be appointed as administrators of the estate, and you'll have to wait for 28 days for any objection. Once there's no objection, 28 days after, the process continues. But for letters of probate, that is not a necessity. You don't do publication, because the testator has already named his executors. Technically, it is relevant in real estate transactions, but it does not stand alone. You still need a deed of assent, conferring title and conveying title to the person that wants to sell.
Welcome back. Did you enjoy the interview? Do you have questions? No problem. Please drop your questions in the comment section. I could answer them and I could forward them to her. She has graciously agreed that she will grant 30 minutes free consultation to all the subscribers on this channel concerning letters of administration, letters of probate. So the link to chat with her will be in the comment section. You can always chat her up from there and she'll be glad to answer your questions. I hope you enjoyed another edition. I'll be with you very soon again. Until then, remember to like and hit the notification bell if you have not. And if you have not subscribed, what are you waiting for? Subscribe so you join this fantastic train as we're moving on in real estate investment conversations. And you could also share, because these things could be a bit technical. You may not be able to explain them yourself. You could share them directly with your friends and loved ones, and you guys can learn together. Until I come your way again next time, remember I always say that I still hold that real estate investments remain one of the juiciest forms of investments in Nigeria and the world over. Take care and bye-bye.